Tuesday of a case file.
Listening you to the court master. Mr. Nath, you're on a wrong bench.
Oh, my item number 3, that's the BRS method.
Okay, so the right bench. Okay.
Daily list item 1 for admission.
Oh,
I'm sorry, my lord.
it's okay.
My lord, the judgment was passed, my lord, long back, my lord. Earlier, the petitioner, he was taken into custody, my lord, on 1/11/2016. Thereafter, as per the order of the Honorable Supreme Court, my lord, he was released on 18/4/2020.
Just a moment. Where is the opinion?
Opinion at page, my lord, 77. My lord, he is now, my lord, 82 years old man, my lord, lodging in detention camp.
He was arrested on, please give the date again.
My lord,
Give the date of arrest again.
date of arrest again, my lord, 25/5/2025.
No, earlier. That
Earlier, my lord, he was arrested, my lord, 1/11/2016.
and released on.
Released on 18/4/2020, my lord. I have also annexed some documents, my lord, that is at page 82. 82
And
and
then again
83.
taken into custody on.
And second time, my lord, on 25/5/2025.
20.
25/5/2025. My lord, he has been, my lord, entering his appearance before the officer in charge till his arrest. My lord, as per my lord, voter list of 1966, my lord, his age is 86 years, my lord. His name is in the 1966 voter list. He was aged about, my lord, 26 years in 1966. At his, my lord, 26. He was recorded as Abdul Noor, my lord. Abdul Noor and Noor Ali. My lord, the person my lord.
Please find out where the affidavit is.
Affidavit is at page 24, my lord.
No. There's another affidavit here.
Or this.
You can show it from the
And-
NCR.
44, 45.
And in the evidence, my lord, one page, my lord, a written statement. Only one page is.
No, that may
written.
be,
And what the, when my lord, he was deposed before the tribunal in 2005, he was 60 years old.
send you this.
Only, my lord, the ground that he is a old ailing person, my lord. Now, as per record, written statement আছে নাকি না? আছে, written statement. এক page,
Evidence of the evidence.
একটু নাই, এক page, one page.
Then,
Hmm?
actually,
Look at the document. This is the trial court record. There's an affidavit here. In the trial court, you filed before the tribunal, you filed an affidavit. There you say in 2002 that your age is 50 years. That will bring your age of year of birth to 1952. Adult franchise will be 21. So in 1973, you get the right of franchise. So in 66, you can't be 26 years.
Yes, discrepancy, that is another part, my lord. That is there. But
We don't know.
But-
This affidavit is of whom? Some other person
Yes.
gave this affidavit. In your case, we need very good people like this everywhere.
2003.
And in your evidence,
my
why
lord-
would you say that I have no documents if you gave vote in 1966? Why would you come to court and before the tribunal and say that I don't have any document?
My lord, in deposition on oath and my lord, as a one page is my lord evidence, one page evidence, my lord, only one page.
You can
There
write
is nothing, my lord.
You can write an
I'm
evidence.
admitted,
even-
my lord. There is
even below
nothing.
that.
There is no merit at all in the case, my lord. I have seen, my lord. But my lord, he is a 86 years old man, my lord.
Help it.
And earlier, my lord, he was in detention, my lord, 3 years in detention, my lord. And after release, my lord, again, he is for last 1 year, my lord, he is lodging in the detention center.
Can't help it.
My lord, 86 years old man, my lord.
We
What
can't
he
help
will
it.
do, my lord? Nothing,
It's
my lord.
it's the risk of her job. Few days back, the
And
Supreme
he
Court of
will,
India
my lord,
had to give a passive euthanasia to a person. So we are in a risky job. We may have to.
even it is
We
not
may have
considered,
to-
my lord,
We may have
he
to
will
hang people
lose
to
his
death.
last breath in the detention, my lord.
He can't help it. There's no document. We're trying to see if we get, if there is
My lord,
any
at least,
evidence.
my lord, the TCR may call for my lord. At this stage, my lord.
We have this.
Yes.
What did I send you? I sent you the TCR, you saw it. You don't know how the trial court records are, we can't help you.
No. Lord, only the ground is that person, well, he is a 86 years old man lodging in the detention camp, my lord, now.
No, please.
And if he is not released, my lord, he will lose his last breath in the detention. It is sure, my lord.
We can't help that. That jurisdiction we don't have.
My lord, apart from this, my lord, the documents, he has, my lord, some documents, 1966 voter list,
He tribunally
1970.
appeared. You see, he tribunally appeared and told that he doesn't have a document.
Oh, he says, my lord, verbally he says.
His written statement is in 2002. He gave no evidence, and then there was a first opinion of 11/6/2003. Then the tribunal recalled that opinion, gave a second opinion in 31/3/2005. In the meantime, he was examined as witness on 9/1/2003.
Only on the based on one, my lord, BW, he himself, my lord. And my lord, the documents, these are not, my lord, even
Ahmed.
submitted, nor, my lord,
Mr. Ahmed, it would be wonderful if you go to all the bar where the foreigners tribunal cases are taken up and educate the members of the bar on how to conduct the cases. You are saying about the length of the affidavit or written statement. How does it matter? We know to write a draft, a plaint can be drafted in
Yes,
four paragraphs.
lapses, my lord, on the part of conducting lawyer also. My lord, all apart, my lord, in the face of the lapses on the part of conducting lawyer, my lord. The petitioner has
Lapses.
been
No,
my lord.
don't accuse him.
No, my
It's
lord,
very
that-
easy to accuse a person who is not before you.
My lord. Page 78 second para clearly says that lordship, he knows the consequence, what will be the consequence of the tribunal's opinion, lordship. Since 2003, he knows, because lordship, what second para says, lordship, page 78, this case was disposed of on 11/6/2003 by a judgment which is already in the record of the case, because the OP
You
to
said
this
that.
case.
We have seen that. We
Yes,
have read
lordship.
that opinion.
Since 2003, lordship,
You read that opinion. Please don't accuse someone who is not before us. You have not made him a party. You have not proceeded against him in the bar council.
Last,
Don't accuse anybody who is not before us. Mr. Ahmed, tell me one question. When you are accusing other advocates, I am asking you. Otherwise, I would not have asked you this
I am not
question.
blaming, my lord. Just, my lord, I am
Please hear us.
advising their.
Please hear us. You are accusing a lawyer of misconduct, of not giving correct advice. You knew the law. Why did you not advise the client the appropriate road? You are yourself conducting a misconduct. You are committing a misconduct. You filed a writ petition in the High Court and don't know the law. It's very easy to accuse others. Look at yourself. What have you done in this case? Did you accuse the lawyer in your drafting? No. Did you advise the client to file a complaint with the Bar Council? No. Did you disclose the name of the lawyer here? No. And then you accuse him. What happened to your knowledge of law? You would have not said this, but you are compelling us to do so. You are referring to a misconduct. It is very easy to point out misconducts. Mistake is something which can be easily found out. Even when you sleep, people will come and say that, no, your posture is wrong. You should have slept like this. It's very easy to accuse. We take exception to that. If you have courage, stand up against for your client, give the name of the lawyer, accuse him of the in the bar council of misconduct. Not before us. We are not the authority to control the advocates. Sorry, we are dismissing it. Heard. Mr. S.A. Ahmed, learned counsel for the petitioner, and so for the respondents. Next, by filing this writ petition under Article 226 of the Constitution of India, the petitioner, namely Muhammad Abdul Ali, alias Abdul Noor, has assailed the opinion dated page 77, dated 31/3/2005, asked by so and so in case number so and so, by which the petitioner was declared to be a illegal migrant within the meaning of section 3 within bracket small c of the illegal migrants within bracket determination bracket close, sorry, determination by tribunals bracket close act, 1983. Next, the materials available in the tribunal's record reveal that upon service of notice on the petitioner, he had filed his written statement on 17/9/2002, and the state examined PW1 on 9/1/2003. However, no evidence was led by the petitioner, which resulted in an opinion dated 11/6/2003 by the said learned illegal migrants within bracket determination bracket close tribunal, Jorhat. Give this second bracket. I am within bracket D bracket close T, Jorhat for short. Bracket closed. Full stop. Thereafter, on an application made by the petitioner, he was allowed to contest the proceedings, and the petitioner examined himself as TW1 on 28/1/2005. Full stop. Apart from giving oral evidence, the petitioner had not exhibited any document. Full stop. Accordingly, the learned tribunal, appreciate on examining the materials available on record, held that Muhammad Abdul Ali is an illegal migrant within the meaning of section C within bracket small c of the IM DT bracket close act, 1983. And accordingly, the reference was answered. Next paragraph. Thereafter, The petitioner was taken into custody on 1/11/2016. So the learned counsel for the petitioner has submitted that pursuant to the orders of bail passed by the Supreme Court of India, the petitioner was released on 18/4/2020. However, the petitioner was again taken into custody on 25/5/2025. Thereafter, the present writ petition has been filed to assail the said opinion dated 31/3/2005. Next paragraph. In this writ petition, it has been projected that the petitioner and the family members are suffering from financial hardship for which the said opinion dated 31/3/2005 could not be challenged. So it is projected that the petitioner is an illiterate person having no knowledge about the proceedings, and moreover, he was not informed or communicated of the opinion dated 31/3/2005 by his learned counsel. So accordingly, it is alleged that due to lack of proper guidance, the petitioner could not assail the said opinion. The learned counsel for the petitioner has submitted that in this writ petition, he has annexed documents including the voters list of 1966, NRC of 1966, voters list of 1970, comma 1989, 1997, 2005, and 2015. Project that the name of the petitioner and his family members appeared in the voters list. So reliance is also placed on the Panchayat certificate dated 16/9/2002 and the Gauhati certificate dated 8/1/2016. Panchayat certificate dated 16/9/2002 and 9/12/2016. Next, it is also projected in this writ petition that the inquiry made against the petitioner by the Superintendent of Police was not a proper inquiry, and based on the vague statements, the reference was made against the petitioner. Accordingly, by projecting that the impugned opinion was mechanically passed without proper application of judicious mind, petitioner plays for quashing of the impugned opinion. Right. Next, the learned standing counsel for the FT and border matters has opposed the prayer for interference with the impugned opinion. Next paragraph. From the materials available on record, comma, the projection by the petitioner that his name appeared in the voters list of 1966 is cannot be said to be a sufficient evidence to prove that the person whose name appeared in the voters list of 1966 is the petitioner and he is a citizen of India. Full stop. In this regard, the court takes notice of the copy of affidavit sworn by the petitioner on 30/9/2002, which is available at page 58-59 and page 59 and and 61 of the writ petition, of the tribunal's records. Purportedly filed by the petitioner, wherein he had disclosed his age as 50 years in the said affidavit sworn on 30/9/2002. As per the said disclosure, comma, the year of birth of the petitioner, comma, as per the said affidavit would be 1952, and therefore his right to franchise would, at the age of 21 years, would only arise after 1973. The said affidavit dated 30/9/2002 was sworn when the petitioner was, and after the petitioner was served with a notice to appear and contest the proceedings before the IM within bracket D, bracket T. As per the order sheet of the learned tribunal, comma, the petitioner appeared before the said learned tribunal on 25/6/2002 and prayed for time to file written statement. Next paragraph. During the examination of the examination chief of the petitioner on 28/1/2005, petitioner disclosed his name only as Abdul Ali. And he did not exhibit any documentary evidence. And he was cross-examined and discharged. As per his evidence in chief, comma, the petitioner claims who have arrived at Singrijan, Singrijan, from Karimganj about 35 years back. When his age was 25 years and got married to one Nurjan, Nurjan, Begum. Of Sivsagar and started residing in the house of his father-in-law, where 3 children were born. He projects that his father-in-law had sold his landed property. As a result, he came with his family members to Rangalu, Rangalu, Moran, Moran, where he started staying at a temporary house in the land of an oil company. He claims to have voted 2/3 times, and later on his name has been cancelled on the voters list as a Bangladeshi. Last comma, even in his oral evidence, in his examination in chief, the petitioner does not claim to have casted his vote in the year 1966 as projected in this writ petition. Next, under the circumstances, it is not open for the petitioner to accuse his learned counsel before the who appeared for him before the learned tribunal, accusing him of not giving proper legal advice. The petitioner, on receipt of notice of the learned tribunal, was aware that he is being accused of being an illegal migrant, yet, no documentary evidence has been exhibited. Next part. Be that as it may, in this case, the opinion was expressed by the learned tribunal on 31/3/2005, and this writ petition has been filed on 29/8/2025, i.e. after 20 years. Having appeared before the learned tribunal and contested the proceedings by filing written statement and giving evidence on affidavit, it is not open to the petitioner to claim that he was not aware of the opinion expressed by the learned tribunal on 31/3/2005. Assuming that the petitioner was not aware of the opinion dated 31/3/2005, but as per his own statement, he was taken into custody on 1/11/2016 and thereafter released on 18/4/2020 and again taken into custody on 25/5/2025. Thus, when he was arrested on 1/11/2016, the petitioner was definitely aware of the reason of being taken into custody. Therefore, the negligence on part of the petitioner to assail the impugn opinion is it appears on the face of record. The Supreme Court of India in the case of Sarwan Sonwar versus Union of India and others, 2005, 5 SCC 665, has equated the influx of people from specified territory to be an act of external aggression. Therefore, in this case, despite the opinion dated 31/3/2005, the petitioner has been able to prolong his stay in the country for more than 21 years without assailing the said opinion dated 31/3/2005, which was assailed for the first time filing this requisition on 29/8/2025. Next one. The learned counsel for the petitioner has cited that the petitioner is currently more than 80 years of age. Of the age of the petitioner would not deter the court to upheld the said opinion so that the consequences of the opinion would follow. That resultantly, in view of the discussions above on merit as well as on the ground of delay and latches, extraordinary delay and latches, the petitioner is not found entitled to any brief in this petition. Next, the petitioner has not been able to demonstrate that the impugned opinion suffers from any perversity or illegality. So accordingly, in exercise of jurisdiction under in exercise of certiorari jurisdiction, it is not open for the court to substitute its opinion against the opinion expressed by the learned tribunal after discussing the materials available on record. Next one. Resultantly, the requisition fails and the same is dismissed, leaving the parties to bear their own cost. Next, the opinion of the tribunal shall, sorry, the consequences of the opinion of the tribunal shall follow. The AC shall return back the records of the learned tribunal along with a copy of this order to be made a part of record by the learned tribunal. This will go to foreigners tribunal. It will go to which tribunal?
Jorhat.
We have written back the record to the member foreigners tribunal Jorhat along with a copy of this order. We made a part of record by the said learned tribunal.
Item 2.
Obligement.
The telephonic information which I have received, that the matter was placed before the advisory board.
Please put on your speaker. Is it on?
Okay. Well, the advisory board, before the advisory board, the matter was placed. And I am told that the advisory board has given an opinion in favor of the petitioner for his release.
Is it?
Logic. That report, I am awaiting. I need 1 day time. By tomorrow, I'll get it. Because the opinion of the board is in favor of the petitioner. So, Lordship, this adjudication may not be required.
day after tomorrow, so that you get one
Mal-
time to.
Mal-
And we'll observe that if the pendency of this reputation is not, reputation should not be a bar for you to take action in accordance with the, because if you want to release it, don't keep him because of this
No,
pendency.
no, not at all. Because they, not. Minor is not with me, but I'm informed.
It's okay, you,
Lot.
you say that we,
Lot.
what's your name?
P. Devi minor.
Miss P. Devi, then
Please,
also
one
the petitioner.
The board will decide.
Also heard Mr. K. K. Parashar, and CEC for the Union of India, and Mr. D. Nath, and additional senior government advocate of the respondents. Next, brother. For the other respondent.
I am for
You will
respondent
be
number
for one and two. You will be for one and two. Huh?
3, 4, and 5.
You will be From 3 to
3, 4, 5, 6. All, my lord.
3 to
Others,
13.
others, my lord.
Next para. At the outset, the learned senior government advocate has submitted that as per verbal instructions received by him, favorable, an opinion favorable to the petitioner has been passed by the advisory board under PIT and DPS Act within bracket respond number 7.
Yep.
He, however, awaits receipt of the written instructions and copy of the order, for which he prays for 1 day's time. That's better. If the information received by the, if the oral information received by the learned senior government advocate is correct, then it is clarified that the pendency of this writ petition shall not be a bar for the consequential action in this pursuant to the opinion expressed by the advisory board under PIT and DPS Act. Next para. List on 19/3/2026.
Madam.
Item 3.
Wait, his lordship. Lordship, this matter is led by Mr. P. Nayak, additional AG. Lordship, he's on legs in court number 5, Lordship. Lordship, we need to pass over the matter for the time being.
Or I can, he said she will come in 10, 15 minutes. Can I recap? I can bring notice so that he can join.
Let him start first because he's the appellant.
Let him come. Because he's the appellant. Yes.
After some time,
Yes.
how much time till we start?
Lordship, maximum half an hour, Lordship, matter is going on in on section.
It's okay.
Let me come after half an
No issue, my lord, no issue.
Yes, item 4.
May I please, Lordship? Lordship, this I is for condonation of 243 days delay in filing the connected repetition, read appeal, Lordship. The delay has been duly explained from serial number 3 onwards, Lordship. Since the approval of different authorities are required for before filing of the appeal, Lordship, some delay has caused. Also, since there was some safety inspections were going on the railway line, Lordship, that also caused some delay.
Oh, wonderful. What is wrong in the order?
Well, the honorable single judge has held that, then,
Yes.
price variation clause is
We
applicable.
we are starting from this point because we have discussed the other points earlier.
Okay.
That's why we are starting from here. What is the error?
Okay. Regarding, lordship, price variation clause is applicable to the tender value as per the honorable single judge lordship. Here, lordship, page 109, the railway board circular lordship. It is of 15/10/2014. Here the subject is lordship price variation clause, addendum and corrigendum slip SCS number 2 to GCC July 2014. Amendment in clause 46A.1 of GCC.
Come to 6, page 110, paragraph 6,
100. Okay.
paragraph 6 of that letter.
Gotcha.
You're showing us.
Okay.
There is example given.
Applicability of PVC based on original contract value. Yes, Lordship. This is an example given, Lordship. If estimated value of a tender NIT value is rupees 55 lakhs, but value of the contract as per the contract agreement is rupees 45 lakhs, then PVC shall not apply, even if the actual final value is rupees 50 lakhs and more, due to variation in quantities during the execution of the contractors. Variation in quantities after signing of the contract agreement is not relevant for deciding whether PVC is applicable to a contract or not. Lordship, para 3. Para 1 and 3, Lordship. We are concerned with para 1 and 3, Lordship. As for para 1, in terms of the Railway Board's above referred circular dated 14/12/2012, price variation clause was incorporated in GCC along with the related instructions. Here it is not stated that GCC in respect of 2014 GCC or all the GCC. So since it was not mentioned that it is not, it was Lordship confined only to 2014. So this Railway Board's letter circular 14/12/2012 is applicable to all the GCCs, Lordship. And this circular is revised in para 3, Lordship. Para 1 of the Railway Board circular number so and so dated 14/12/20 is revised as under. Earlier, Lordship, it was price variation clause shall be applicable only for tenders of value rupees 50 lakhs and more, irrespective of the contract completion period. Modified content, price variation clause shall be applicable only for contracts of value. Earlier, it was Lordship tenders of value. It was revised to contracts of value. By its modification, Lordship, of rupees 50 lakhs and more, irrespective of the contract completion
Page
period.
105 is your
In
is your
100,
policy.
this is the 105, Lordship. This is later on, it was
This
another
policy is applicable or not applicable?
applicable, Lordship.
Is applicable.
8, Lordship, para 8.
Then
Please.
come to 8.0.
8.0. 8.0 price variation clause in works contracts is dealt with in accordance with the provisions of item 46A of GCC July 2014. In order to simplify and enhance the pace of the works, it has been decided to remove the PVC clause in all works contract tenders having value less than 5 crores. Yes. So, Lordship,
So therefore, tender is not the works contract, it's a tender. That is how the learned single judge has arrived at a finding. So what is wrong? That's why we are starting from that.
Lordship, as per the first line, a price variation in works contract is dealt with in accordance with provision of item 46. So, Lordship, PVC is, Honorable learned Lordship, single judge held that the GCC 2014, this 2014 circular is applicable only to the GCC 2014, not to the GCC 2019, since we are in GCC 2019. But as per this para 8.0, Lordship, this GCC 2014 is applicable, Lordship. Price variation clause is dealt with in accordance with.
2019, you have the GCC 2019 with you.
No, so it was not annexed in the repetition or in our.
This
My
contract is of-
friend, standard condition contract, work 46(1) and GCC 2019 is the same, like.
No, this contract is of which year? What is the date of
19/12, 13/12/2019, and GCC 2019 will come into force, my lord, from 9. One second. Very quick second.
6/9/2019. And when there is a, my lord, 2000,
Where is your, what you call this contract agreement, which page?
page, my lord, contract agreement, my lord. Contract agreement. Page 87, my lord. No? 86, this is another. Yes, this is my lord. 87.
Page number?
50, contract agreement 54, lordship. 87 to 10. Go page number 50. 54.
This is letter of acceptance, but where is
Letter
the
of
contract?
87, my lord, contract agreement. Is going to. Letter of acceptance is 53, lordship. There is a contract agreement number, Spencer. 54. Article of agreement, this, I cannot read, my lord. Where is the railway perform the work?
No, this can't be. This cannot be yours. At page 55, the letter of acceptance is 4/3/2020. There cannot be an agreement before letter of acceptance.
Yes, fine.
Then where is your document?
Lordship, letter of acceptance was issued earlier, lordship. On the strength of letter of acceptance, they can start work. After that, lordship, the contract was executed.
What is the date of the contract? Tell me. Alice.
Contract is of 28/8/2020, lordship, page 54.
54.
The first line, second line, lordship itself. 28/8/2020. 28/8/2020. Yeah. After the lordship, LOA was issued, thereby authorizing them to start the work, lordship. And after they submit their performance guarantee, all this, lordship, then this contract was executed. One document was not, my lord, annexed in the retail, my lord. Everything will be clear on the affidavit. Because GCC also there 2000 standard condition of contract also there, my lord. PVC above 5 lakh tender value is applicable. And when new GCC 2019 has come, everything, my lord, has been, my lord. Other, my lord, document which has been sent by him is a redundant document, because GCC 2019 that is not available now. That in GCC 2019 it is clearly stated that, my lord, that the PVC will be applicable if it is mentioned in the tender, my lord. And tender it was mentioned, 2.18. That GCC tender value above 5 crore, this is applicable. The Honorable Single Judge has accepted the 0.8 lordship of notification dated 8/2/2018 to the effect that 5 crore, the limitation will be the 5 crore, 5 crore. If it is lordship accepted this notification, lordship, then the
Just
first line has also to be accepted, lordship.
Both sides are represented. Mr. NNP Chaudhary, learned counsel for the respondent, has submitted that in the connected unregistered writ appeal, memo of writ appeal, the applicants have not annexed the affidavit in reply filed by the petitioner. So it is submitted that the said affidavit is very relevant as the respondent has taken a stand that as the tender was issued on 13/12/2019 and the contract agreement was and the letter of acceptance was issued on 4/3/2020 and the contract agreement was signed on 28/8/2020, the GCC 2019 is applicable. Full stop. Next para, as the memo, as the memo of appeal in the connected unregistered writ appeal does not contain the said document, the court is inclined to call for the records of WPC 4297 of 2023. Next para. That this order be brought to the notice of the AOJ writ appeal section. Next para. List the matter again on on 19/3/2026.
I have a submission, my lord. In contempt petition, they have always taken plea, writ appeal is pending. This honorable court has passed this order. You also kindly peruse this order of contempt, my lord, important, my lord, because they always take this plea. The writ appeal is pending.
Lordship, my stay application may be considered, Lordship, since contempt petition is pending. Still,
You also kindly go through para 11, my lord, and other, my lord, other part. Always taken this plea, my lord.
No, you see, we will make it very clear. Since it's an appeal by the Government of India,
Lordship,
we are inclined to take a lenient stand of not annexing the entire documents.
Lordship,
Because if you insist on the stay, then we'll be dismissing the writ petition, the writ appeal on that ground alone.
Lordship.
It is for not you to elect what documents the bench would read. Your duty is to annex all the documents. It is for us to decide what to read, what not to read.
Lordship,
You
it was
don't
not even
annex the
on the-
documents in accordance with the entire set of documents. Why would you hide
No, Lordship.
few
it
pages
is
from us?
Not high, Lordship, whatever documents I have been provided, Lordship, there was not a copy of this affidavit.
You see, we
by-
gave you sufficient indication on the last occasion.
Lordship.
You still make that same submission which you made a week back. Last day, you made that submission. Exactly same submission was made on 10/3/2026. Today we are in, what is the date today? 17th.
17.
So you get 7 days time, but you did not get the instructions.
Lordship, on the next date, we will
No, then we
produce a
dismiss it
copy of
today.
GCC and.
Then we dismiss it today.
No, Lordship.
Because we remember what happened on that day.
On that-
You don't produce the document and then you take a risk. So we are now dismissing it. You don't elect what document the bench would read. It is your duty to protect all the documents. Sorry, we are dismissing it on that ground alone. Then don't write this. Last time don't write. Then you say, moreover, on a cursory perusal of the memo of appeal, we take notice of the fact that even the contract agreement is not complete. Full stop. Although the stand taken by the respondent in their affidavit in opposition in the writ petition was that GCC 2019 applied, but yet no document has been shown as to the applicability of the GCC. Although as per the projection of although as per the materials available in the connected memo appeal, the letter of acceptance of the contract is dated 4/3/2020, and the contract agreement was signed subsequently on 28/8/2020. Full stop. There is no material in the connected memo appeal to show how GCC 2014 applies. Next para. Therefore, notwithstanding that the court is presently dealing with an application for condonation of delay of 280, how many days?
243 days.
240. 243 days, but on examination of the connected memo appeal, as the documents are not completely provided, the court is of the considered opinion that the delay ought not to be condoned of 243 days when the respondents are aware of the implication of the order passed by the learned single judge, and yet in the connected memo appeal, incomplete documents are annexed. Therefore, next para. Therefore, on the ground that on two grounds, i.e., that number one, that the delay is not sufficiently explained to show what prevented the applicant to file the appeal and why, which is relevant because it appears from the statement made by the learned counsel for the respondent that in the meantime the respondent had initiated a contempt petition, and that only on receipt of a notice in the contempt petition, the present appeal has been filed. Stop. The second ground for dismissal of this application is that the entire set of documents which are relevant have not been annexed in the connected memo appeal, and therefore no ground is made out to condone the delay. Resultantly, the delay is not condoned and the application is dismissed. Resultantly, the connected memo appeal is also stands dismissed.
Item 5.
Your document on Mr. Deepalodi, your document.
Lordship, can it be on their side tomorrow, Lordship? Or yes, Lordship, but earlier Mr. Pang has handled this case, Lordship. He is not available today, Lordship. Yes.
My lord, on 24th, my next Tuesday, my lord. 24th, my lord.
No.
Item 6.
Wait, please, your lordship. Lordship, in this case, lordship, I have been declared as a foreigner, lordship. On one count, lordship, I could not prove the Gauhati certificate, exhibit C and D. Lordship, it is my case is that, lordship, my father was in fact a citizen of East Pakistan, lordship, and I have entered in the year 1966. After that, I have purchased the land in the year 1966, which I have exhibited as Exhibit A. And subsequently, to prove my link, I have exhibited Exhibit C and D, lordship. But the Gauhati was not cross-examined, lordship.
If you came in the year 1966, then also you should have got yourself registered first.
I have not come. My father had come. Lordship.
Even your father would have to be, ought to have registered himself. So mere presence in 1966 doesn't help you.
My lord, if I may just point out one thing, lordship. The Gauhati certificate, lordship, I have produced it in original. Now, lordship, as per section 62 of the Indian Evidence Act, for the purpose of section 50, it would have sufficed, lordship.
62 primary evidence.
Primary evidence.
It doesn't become a primary evidence. We'll ask you a series of questions you'll understand. Number one, according to you, what is the meaning of a certificate?
It is certified by.
It certifies what? I have a metric certificate. What does it say?
Lordship,
It would say that so and so has passed this examination. He was successful. That's all. Now, is it a primary evidence?
no, I'm not saying that, lordship. Only for the purpose of section 50, lordship. Not for
50, 50.
lordship. For forming an opinion, lordship. Not with regard to any other purpose, lordship.
Please see section 50.
Lordship, opinion on relationship.
Yes.
When the court has to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of relationship or any person who, as member of family or otherwise, has special means of knowledge on the subject is relevant. Now, in this case, lordship,
And provided that such opinion shall not be sufficient to prove a marriage
that
in a
is-
proceeding in the Divorce Act or in a prosecution under section so and so of the Indian Penal Code.
no,
Correct. Now,
lordship, or my only submission is with regard to forming of opinion, nothing else. Otherwise, lordship, I also consider the lordship law.
no, because I am giving another horrible example. I give it every day. I am repeating it now again. See, I give a certificate that, let us say, think of any big name, Isaac Newton or someone, that he's my son. Just think of a name and then I give a certificate that I give a declaration and affidavit saying that XYZ is my son. It's absolutely impossible. He expired before I was born. He couldn't be my son. But I give that certificate. Now, somebody questions me and laughs at me, and I come here and I ask all of you that, well, I have given this certificate, I need some help. Every one of you stand up and say that, no, we will also certify, we will give a certificate that so-and-so is your son. We won't disappoint you. So all of you, I get 20 certificates today saying that X is my son. Now, will it be sufficient to prove relationship under section 50? 50 says, when a court is to form an opinion as to the relationship of one person to another, the opinion expressed by conduct as to the existence of such relationship. So that conduct was never was a part of the evidence of any person who is a member of the family or otherwise has special means of knowledge on the subject. Therefore, this would include one. It would include, if I am the declarant, it will exclude me. Other members will have to tell. I can't give a self-declaration. Now come to 112.
First, during marriage,
A fact that a person was born during the continuance of a valid marriage between his mother or any man, or 280 days after its dissolution, mother remaining one shall be conclusive proof that the legitimate son of a man, so and so. So when it's sonship, you see what happens is that in a family earlier days, people used to keep someone who had no parents, treat him as a son, get him married, give them property, treated as a part of the member of the family. And it is at that stage that evidence is required to be given as to how he was treated in the family. You read that case, it will be very good for you if you have time. Don't spend time on that because it's endless. You can't just. It's a huge judgment. It's called Bhwal Sannyasi. Case of Bhwal Sannyasi. Raja. It's a Privy Council case.
Yes.
Srimati Prabha Devi versus R.N. Roy. In this case, what happened was that the son of the Zamindar in West Bengal, then undivided West Bengal, including Bangladesh, he died of a snake bite. And his dead body was left in the Ganges to float away. So that at that point of time, they did not used to cremate people who had died out of snake bite. They just leave it in the water. And this man was declared to be dead. After many years, the villager, one village lady, went to pay respect to a sannyasi. And while going down to the sannyasi, she saw the legs where the symbol of that king was, that Raja was there. And therefore she claimed that this is that prince of that estate. And in this trial, more than 1,000 witnesses were examined to say that how whether this man is there or not. If this man lost the man Bhaval Sannyasi, he lost his memory. He does not know. And then this suit went and he was declared to be the legal heir of that estate. So there, this question arose for the first time. How this, whether this man could be the son of so-and-so, when there is no evidence at all, just by the symbol which, or some mark in the legs was found. So that is how it is treated. There was no certificate of birth. There is no link with the family. Yet, by way of evidence, it was discussed, and section 50 was discussed here. Because then the subject matter of question would be the relationship itself. But in this case, the citizenship is not a subject matter of question. It's the citizenship. So whether section 50 would apply or not, you'll have to satisfy me more elaborately. We don't find this, will be relation, the oral evidence. There are many judgments. He will give you 2 or 3. This court has decided that oral evidence is not a proof of sonship. There is another very simple example. You would find me addressing my esteemed brother as brother always. Now, if a question arises whether we are actual brothers, then the answer would be no. By showing respect to the other side, we call them uncle, brother. We even call people as father. Doesn't create a relationship. The relationship is how you treat, how the family treated the person.
But apart from that, I do not have any other defense, Lordship. Lordship, if I may just pray, Lordship, if Lordship may give me some time to approach the CA authorities, because I am a Hindu, Lordship. If I can avail some benefit, otherwise, Lordship.
We'll just really adjourn it on your prayer, because this is something we can't observe in the order sheet.
Lordship.
There are 2 decisions of the Supreme Court which operate against that way.
Lordship.
We just adjourn it for a month. In the meantime, both sides are represented on the order. Prayer made by the learned counsel for the petitioner. The matter stands adjourned today. Let's give a date after 4 weeks. Give the name of Mr. Peter Capo, learned counsel.
27/4.
27/4.
Lordship, the second case, Lordship, similar grounds, Lordship. In that second case, Lordship, there were 5 family members, Lordship, out of which 4 have been already declared as Indian
The
citizens.
same family.
Same family.
This is this family. Item number 6.
7. 7, Lordship.
No, 7 is related to item number 6. No.
No.
The same order here in item number 7. Yes.
Lordship, similar with respect to here, 7.
Adjourn it.
I'll look.
Indeed.
9, 6. 7.
Item 8. Item 8.
Item 8.
There's no representation from the promotional. All the respondents are represented. Next, for ends of justice, the matter stands adjourned today. It is made clear that if the petitioner remains absent on call on the next date of listing, adverse orders follow. Next, list on 24/3/2026.
Item 9.
Lordships. Lordships, the impugned opinion is just page number 69, Lordships. 5 witnesses was examined. The petitioner, father, mother, school master, and village headman. Linkage are village headman certificate, school certificate, and voter ID. Very good. And police report was also called for from SP Nalbari as well as SP Dharam. And report has been received by this court regarding whether Ibrahim Ali is father of the petitioner or not. Because he is permanently residing at Dorong, Borwazan, but second wife was at Nalbari district, Kashimpur at Nalbari district.
Any voters list prior 2002, immediately prior to 2002.
Only up to 13, that is the voter slip. But 65, 70, these are also given. And last was 2013. But these are not certified copies.
Please try to
Certificate
understand the question. We are asking you a simple question. Please show us any voters list immediately prior to 2002.
No.
No.
Not certified, Lordships, 2013 also, but not certified.
But if we are not interested, 2002 is a reason for asking.
In page number 22,
What is there in 22?
it is a evidence of OP number 2, OP number 1. And page number 68. House number 233. Serial number 233.
Just a moment.
68.
Which page is your written statement?
Written statement. Written statement 70. Page 70.
You don't have a voter's list with your father.
Lordship. Father voted in Boruazar, Dorong district.
Please, try to restrain yourself. We are not asking you the history. We are asking you a simple question. Is there a voter list? Is your father?
Yes, father. Father.
Where is that?
Lordship. Page number 37.
P7.
Voter list of 1985.
You are with your father.
Ibrahim Ali. Father.
Where is your name here in 85? 85, where is your name?
Ibrahim Ali and Ankima. Ankima is my stepmother and Ibrahim Ali is my mother.
His name is not there.
My name is not here.
Then what did you hear? We asked you question twice.
My,
What did you hear?
Because I was born only in
Mr.
1985.
Please don't waste the time of the court. We are asking you a specific question. We desire a specific answer. We asked you a question, where is your voters list where you and your father's name appeared?
No.
And you said yes.
No, sir. No, Lordship.
So if it's not there, what's the
No.
difficulty in telling no?
The
Why you are taking us? to
hearing
the
also
state
problem,
of
Lordship.
then
Hearing also, but hearing it is not with me today.
that is your responsibility.
Lordship. Lordship.
Did the doctor tell you today or your pharmacist told you today to go to court without hearing and
Lordship.
hearing aid?
Lordship.
If you're not wearing it, it's your problem. You did not tell us about the disability earlier.
My name is not with my father. Only with my mother. That is uncertified copy. That is 2013. With
Then
my mother.
how you are connecting yourself to your father?
As per school certificate, as per voter ID and village admin certificate, means the legal certificate.
Where is that document?
Voter ID at page 48, Lordship.
School certificate?
Lordships. Chunar Ali, Father Ibrahim Ali.
School certificate?
School certificate.
Which page?
School certificate. School certificate. 13. 14. Village admin certificate 61, Lordships. School certificate I am finding out.
school certificate at page number 34, and voter village admin certificate 61. Vernacular 35.
Full certificate is it page?
Full certificate on top.
Yeah, 35 losses. Vernacular 35 and 34 is type of.
Any voters list of you, of your father at Kashimpur? Any voters list of your father in village Kasimpur?
No, no loss.
And just asking you a question. Supposing I have a ward, I want to give him admission in, let us say, think of a school, okay, Assam Valley School at Tejpur. We want to give him admission there. According to you, what is the address I should disclose in the school if I want to get him admission in a school outside Gauhati? In the school, what is the address I should disclose? Supposing I have a ward which I want to give admission in a school outside Gauhati, what do you think I should disclose as my address?
Require lordship.
Hmm?
Requires address also.
Pardon me?
Address also of the students who enroll in a school, his address also
No,
required.
I don't know. I'm just asking you. I have a ward. I've not said whether he's my son or daughter or something. He's my related or not. I have a ward. So I'm a guardian of some student. I want to get him admitted in a school outside Guwahati. What is the address I should disclose?
Whenever in a school or college admission form is supplied or furnished, that this is to be filled up with address also.
Which address?
The address where I reside, permanently reside. And sometimes the local address also required.
Okay. Then come to your certificate at page 35. At page 35, what is the address disclosed? Kasimpur. We asked you a question as to whether you have a voters list in Kasimpur. You said no.
Voter list, no, but
It's not a question of voters list. It's just an address. I wanted to know the
as per
address.
school record, the headmaster found and
Headmaster finds.
that's
No. You don't say anything. Headmaster gives the address.
on the other
It
hand,
is only because of
mother also Indian
if,
citizen,
if,
mother.
the, if the headmasters are like this, that is why on 5th of September we salute them. They are the trustworthy people who are doing everything. Even if you don't say something, they write it.
Some question ought to have put in cross-examination, but no checking. No question was put regarding father. That Ibrahim Ali was not a father.
Why would I ask a question?
Hmm.
Also, we have not asked you a question about that. We are just beating
And
around the bush here and there and
That
asking
ought
things.
to have led rebutable evidence.
No, it is your case that he is my son. I am a resident of Kasimpur. But you don't show anything from Kasimpur. Then you make a strange statement. When you find that you are not a resident of Kasimpur, before the tribunal you create a story. You say that my father left my mother in her parental house. Father keeps on visiting, my mother also keeps on visiting, but they don't stay together. The year of marriage is not known and you are born in 1985. So your father's and your name is nowhere there. Then there is a school certificate saying that your father's father resident of Kasimpur.
Village admin also examined, Lordship.
But look at the certificate. Village resident of Kasimpur. Was your father a resident of Kasimpur? That's a question we have not asked you as yet.
Village admin also mentioned his father name.
Because
And
your
also,
statement,
he was examined
your
for
evidence does not say that your father resided in Kasimpur. So we are not asking you that question. You say that my mother and father had a relationship maintained. So your father resided in a different village, but your address is disclosed in Kasimpur. How?
And for this question was arose earlier also. That is why a police verification report was called for from Nalbari as well as Darang district. And that has been received.
It's not necessary. We can't create an evidence here or look into it.
My father and mother was examined and cross-examined. Lordship, in the reference as well as in the form 1 and 2, in all cases, my father's name is Ibrahim Ali, but not disclose the address of the Bangladesh or Pakistan. And my parents, in para number 13 of the form A, only Ibrahim Ali, my mother's name is not written, but here is parents' name. My mother is living with me, and my mother also submitted documents regarding his voter list and grandparents, maternal and grandparents, voter list of 65 and 70 also submitted. I was born 1/1/1987. So before 1/1/87, so 1/7/87, 3rd July 1987. So I am Indian by birth.
Matter is still going on in code number 5.
That lordship knows the Jaimala elephant, the Jaimala one elephant was given to Tamil Nadu from government of Assam. That case is going on. And Mr. Nayak, my lord, till now could not study the argument. So I don't think he can finish today, my lord. Can be taken about next day after tomorrow, my lord, 19th. Let's try our luck, my lord. 19th. Question of luck is also there sometimes. In the way, yes. Yes. 19th kindly, my lord. Let's. That case he has to started here. Does it? Okay. My lord, so much is concerned. It's all right, my lord. I can see. Three. Day after 19th, my lord.
March,
19th.
if possible.
Let's try your luck, my lord. The cases are matter of luck, my lord, actually. Sometimes, most of the time I have seen. No, luck means on the day, bad or good is a different issue. But the question of luck is there. My lord, some extent there are, my lord. Obliged, my lord.
Lordships,
Yes, Mr. Pandit.
as per Lordships, the reference supported by the two forms, that is the first form is at page number 65. There is no main ground actually, because page 65. Para 3, address of the Bangladesh or Pakistan, not disclosed. Again, para 13, Lordships, name with address of the other family members. Number 1, parents, Ibrahim Ali, not mother is mentioned. Parents, name of parents. Again, Lordships, page 67, the form 2, same, para 5, address of the country is not disclosed. Police station, district, country not disclosed. And 12, page 68, page 12, the person has entered. If the person has entered to India without passport, how person entered India? Name and village, district from which persons entered, and date of entry. Illegal road, only illegal road. So main ground is not given in the case, in the reference. So as per Lordship, Foreigners Tribunal's Order 1964, clause 3, the tribunal shall serve on the person to whom the question relates a copy of the main grounds, on which he is alleged to be a foreigner, and give him a reasonable opportunity to making a representation produce evidence about the case. No main ground is here. No main ground. And my date of birth is 1/9/1987. But as per Citizenship Act, Article 3, citizenship by birth, on or after 26th day of January 1950, but before 1st day of July 1987. Then, exception provided to every person born in India shall be Indian by birth. On the other hand, B, Citizenship Act, Article 3B, on or after 1st day of July 1987, but before commencement of the Citizenship Act, Amendment Act 2023, and either of whose parents of citizen of India at the time of birth. Either means my mother is also here, my mother is with me, and my name reflects in the voter list with my mother, and my maternal grandfather's name also given, a 65 voter list. The Hazrat Ali is my maternal grandfather.
Okay.
That had not properly verified and led any irrefutable evidence. So the petitioner is India by birth.
Yes, Mr. Sharma.
Lordship, what my learned friend has said, Lordship, regarding section 3, Lordship, this is a general provision. And 6A is the special provisions, Lordship, which always overrides the general provision, Lordship.
Oh.
So, Lordship, in this case, Lordship, 6A is applicable, Lordship, not section 3 of the Citizenship Act.
6A.
First submission is there, and in secondary, Lordship, only thing petitioner has to establish his link with his projected parents whose name appeared in the voter list of 1966 or any document which is available prior to 1966 or from 1966, Lordship. So here in this case, Lordship, after 1966, Lordship, in 1966 voter list is of one Songser Ali of village Buruazar district, Dorong, Lordship. Even Lordship, his projected father also cannot able to establish his link with this person, Lordship, Songser Ali, whose name reflected in 1966 voter list. Then, Lordship, what is clear, Lordship? Only remaining thing is that, Lordship, to establish his link, Lordship, he relied on Gaubra certificate and Lordship school certificate. And page 72, para 8, opinion reflects that, Lordship. The OP also examined Muslim Ali, aged about 50 years, son of late Baju Ali of village Kasimpur, as his OPW5. He reposed inter alia death. He issued the Exhibit 14 certificate as headmaster. He issued the certificate on request of the villagers and Fatima Bibi, that is projected mother of the petitioner. He did not brought admission register or any other records of the school. So this school certificate, Lordship, does not help the petitioner to establish his linkage with projected person. And Lordship, para 7 also, Lordship, important, Lordship. This is regarding Gaubura's certificate.
Just a moment.
Eight. 78.
Mr. Sharma, are you aware of the meaning of maybe a local colloquial term in the Nalbari? Hatsita. Are you aware of the meaning of this term? Hatsita.
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 Oh. Sita.
Handwritten slip. Is it handwritten slip?
Yes, Lord.
This is a term from Nalbari, so anybody from Nalbari will be able to tell us. Hatsita.
I am from Nalbari.
Are you aware of the term Hatsita?
Not now. Earlier it was, I have heard, earlier Hatsita was maintained by the Gaubura, but not now.
So
And
what
it is also here.
What is Hatsita?
Hatsita. হাতে দিয়ে লেখা মানে record or records which are maintained by Gaubura. Oh. প্রথমতে আছে 20 29 34.
Yes, Mr. Sharma. Just now. Yes.
So, Lordship, secondly, Lordship, Gaubura certificate, Lordship, Gaubura, what Gaubura has deposed, Lordship. In this case, Lordship, opinion, from opinion, I am reading, saying, Lordship, page 72, para 7, the OP also examined Dipul Boro as at about 40 years, son of late Samin Boro as his OPW4. He deposed inter alia that he became the Gaubura of village Kasimpur in 2006. Exhibit 15.3 is a register maintained by his father in 2005, where at serial number 76, the information relating to the OP is written. The entry were not written either by his father or by him. It is not written in the register form, which date of OP and his family started residing in village Kasimpur. The register is not in torn condition and the pages are not in order. So, Lordship, although he placed one registered Lordship where proceedings name has been reflected, Lordship. So, Lordship, but Lordship, who made this entry, they does not aware about it, Lordship.
Might be by assistant or clerk.
Yes.
Lordship, myself, Lordship, I have interest, Lordship. Yes, Lord. Lordship.
Lordship dispose it.
Lordship.
Anyway,
So, Lordship, regarding Gaubura's certificate, Lordship, I want to rely on a decision of this court, Lordship, 2018 4 GLT 354. Lordship, Jalaluddin, JALALUDDIN, Citation 2018 4 GLT 354. 4 GLT 354. Lordship, para 24 and 25, I am relying in his deposition before the tribunal, DW2 Moniruddin stated that he was the Gaubra and that he had issued Exhibit A certificate, but on going through the entire evidence of DW2, it is seen that he had issued Exhibit A certificate on the basis of personal knowledge, but interestingly, he did not say, and the certificate is also silent since when he knew Muhammad Jalaluddin, while DW2 might have owned up Exhibit A certificate, that would not ipso facto mean that contents of the certificate were proved. The contents would have to be proved on the basis of contemporaneous record mentioning the serial number 1774 of 2015 in the certificate is indicative that previous certificate were issued by the Gaubura and that such certificate were issued from certain register. This register was required to be produced before the tribunal and the contents of the certificate was then required to be proved from the register, but this was not done. It is to be borne in mind that para 25 is important, Lordship. It is to be borne in mind that the contents of the certificate would have to be proved from the record, though the author of the certificate may prove the document through oral evidence, but oral evidence, the horse record, cannot prove the contents. Contents of a document based on record cannot be proved from personal knowledge. Therefore, contents of Exhibit A cannot be said to have been proved. So, Lordship, here in this case, Gaubra issued the certificate on his personal knowledge, Lordship. So, that certificate will not have the procedure to establish his linkage. Apart from that, Lordship, oral evidence of father and mother without supporting documentary evidence, Lordship, will not help the procedure to establish his link with his projected father. Lordship, regarding oral evidence of father and mother, Lordship, I am relying on decision of this court, Lordship, 2023 GLT 347, Noor Begum, NUR, Noor BGUM. Citation 2023 GLT 347. Para 6, Lordship. The statement of DW2, that is Zohrun Begum, who claimed to be the mother of the petitioner, cannot be relied upon in absence of any document showing her relationship either to the projected grandfather, father, or to the petitioner herself. Oral testimony of DW2 alone, since any documentary support cannot be treated as sufficient to prove linkage or help the cause of the petitioner. Surprisingly, the petitioner Yes, Lordship. Surprisingly, petitioner failed to produce a single voter list in her name even until the age of 50 years. We would reiterate that in a proceeding under the Foreigners Act 1946 and the Foreigners Tribunal Order 1964, the evidentiary value of oral testimony without support of documentary evidence is wholly insignificant. Oral testimony alone is no proof of citizenship. Then, Lordship, regarding oral statement of father, Lordship, here, WPC 4020 2017. Asia Khatun, ASIA. Asia Khatun, KHATWN. WPC 4020 of 2017. decided on 21/11/2019. Lordship, regarding oral statement of Father Lordship, here paragraph number is 7. The statement of DW2, that is Amiruddin, who claimed to be the father of the petitioner, cannot be relied upon in absence of any documents showing his relationship to the petitioner. In this, we would observe that in a proceeding under the Foreigners Act 1946 and Foreigners Tribunals Order 1964, the evidentiary value of oral testimony without support of documentary evidence is solely insignificant. Oral testimony alone is no proof of citizenship. The evidence of DW2 thus falls short of being considered as cogent, reliable, and admissible evidence, so much so to establish linkage of the petitioner to him. Here, Lordship, although father and mother comes before the tribunal to adduce on behalf of his projected son, Lordship, but there is lack of document, Lordship, by which Lordship proceeding can establish his linkage with his projected parents, Lordship Ibrahim Ali, or Lordship his grandparents, namely Shamsher Ali, Lordship, whose name reflected in the 1966 voter list, Lordship. Apart from that, Lordship, if we consider the voter list of 1985,
It will be readers. Itu
36.
36.
So Lordship, if we consider the voter list of 1985, Lordship, here projected mother's name has been reflected at the age of 25 years. But connected person's name is reflected, Lordship, Ibrahim, but this Ibrahim's continuity is not seen from 1966, Lordship. Page 36, Lordship. Fatima Bibi. Yes, Lordship. Oh, yes, Lordship. Not same. Yes, Lordship. Sure. Yes. Oh, Lordship. Yes, Lordship. Yes, Lordship. Lordship, this entry number 130, Fatima Bibi. This is the projected mother of the proceeding. So, Lordship, in 2013, voter list page 60, is Sunahar Ali's name and his projected mother's name reflected, Lordship. But what I'm going to say, Lordship, this Fatima Bibi's existence should be there with a person who is continuously present in the territory of Assam since 1966. That was not there, Lordship. She is not the projected mother of the proceeding, Lordship. Projected mother of the proceeding. Lordship. Yes, Lordship. But there is no such document by which proceedee can able to establish his link with the person whose name reflected in the voter list of 1965. Lordship. That's all, Lordship. Page 36, 1985 voter list.
Lordships,
Why I am saying?
I am a genuine citizen of India. Lordships, I would like to place citation of Muslim Mondal, Lordships. Muslim Mondal. It is page para 121 and para 122 mainly. In 122 school certificate also here. The tribunal, however, overlooked the evidence of the appellant 121.1 para that she was born and brought up at Patikusi under Borbeta police station, and she was a student of military high school. I am born and brought up Kasimpur, and I am school Hussein Ali LP school. The appellant has proved Exhibit A, the school certificate issued by headmaster, which was not disbelieved by tribunal. Such positive statement of appellant has not been challenged by the state during cross-examination. Cross-examination, no checking, and no irrefutable evidence led by the state. There being evidence on record, the appellant is born and brought up in the state of Assam. There being no evidence, not even an allegation of the appellant's parents are foreigner. So, the writ appeal was allowed. This is para 121 and page 65. And another same judgment 122 para 22.1 read appeal number 281 of 2008. The appellant, in order to prove that she is a citizen of India, not a foreigner, examined two witnesses, namely appellant herself as well as village headman. The appellant also proved 10 documents which mark as so and so. The appellant, by probing the electoral rolls, would probe the names of the father and mother appeared in such rolls. In respect of Jonia LSE, and thereafter her name appeared in electoral 1989 in respect of Bagbor LSE. The answer could prove certificate issued by village headman, certifying that appellant is daughter of Sahib Ali. The appellant therefore proved her father's name is Sahib Ali, whose name appeared in the electoral roll 1966 and 70, which are relevant for the purpose of answering the reference made under the provisions of 1964 Act and 1964 order. Though state has cross-examined the witnesses, there was absolute no cross-examination relating to the claim of the appellant that Sahib Ali is his father. Here also, in our case also, there was no cross-examination that Ibrahim Ali was not father of the proceeding or petition. That is para 120.2 and page number 66. Writ appeal number 281 of 2008.
I am also relying on para 112 and 113. In respect of certiorari.
Lordship, over and above, the SP was directed to verify whether Shunail is a son of Ibrahim Ali. Both district, that is Nalbari district, the proceed is original resident, and also father's residence now at Boroa under Doran district. Both district SP submitted prohibition report, whether Shunal is the son of Ibrahim Ali or not. And actually, there is no ground and close attached with the notice. There is no place of his original residence, where from he was coming, through which road. These were not mentioned in the Form 1 and 2.
সেইটোহে মেনশ্যন কৰিব যিটো কয় সেইটোহে মেনশ্যন কৰিব
Lordships, as per provision of Foreign Tribunal Order 1964, clause 3, they are mandatorily required. That is, main ground is required, and in this respect, citation, Muslim Moldors, same judgment, a read petition number, para 124, Lordship, 124, Lordships, page 67. As already has been 124.1, para 124.1, page 67, regarding main grounds of the notice. It is mandatorily required. As already been held above, proceeding must have served with a copy of the main grounds, one which he or she is alleged to be a foreigner. As noticed above, the records of tribunal do not reveal issuance and service of main grounds, one which appellant is suspected to be a foreigner. Non-service of such main grounds, though mandatorily required, amounts to denial of reasonable opportunity to the appellant to defend himself, thereby violating the principles of natural justice. The said aspect of the matter has not been considered by the single judge also. That it is made in our reference, there is no ground, because where from I have come, through which road, there is not written. My father's name is written, my mother's not written, desired to be written. There is no ground. Bangladesh, where from? Whom district? From which village not written. So there is no main ground. It is also appropriate judgment.
Petitioner and so for the respondents. Next one. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 30/8/2017, page 69, passed by Swinson, thereby declaring the petitioner to be a foreigner of post 25 to 1971. Next. The learned counsel for the petitioner has submitted that the petitioner was not served with the grounds of suspecting him to be a foreigner, and therefore the petitioner did not get a reasonable opportunity to defend himself. This further submitted that the petitioner was born in India in the year 19. When were you born? When were you born?
Kasimpur in the village Kasimpur, and then all.
When?
One on 1987.
On 1/1/1987,
Yes.
and therefore the petitioner would be a citizen of India within the meaning of section 3, one A of the Citizenship Act, 1955, having acquired citizenship by birth. Accordingly, it is submitted that the petitioner could not have been suspected to be a foreigner. It is submitted that this court had directed the superintendent of police within bracket border Dorong, as well as the superintendent of police border Nalbari, to make a verification as to whether Ibrahim Ali came to village Kasimpur, where he had married Fatima, and the petitioner was born, but the mother of the petitioner but Fatima remained in Kasimpur, whereas the projected father, Ibrahim Ali, went to his original village at Orwa Jhar, Paruajhar, and he occasionally used to visit Fatima. It is submitted that both the reports are available, which show that Ibrahim, son of Sangsher, Sangser, Sangsher, was the father of the petitioner Muhammad Sumahar, Shunahar, in Ali. It is submitted that the petitioner had examined himself as OPW1 and had exhibited 16 documents, and that to prove the linked document, the petitioner had examined his projected mother Fatima Bibi as OPW2, as well as Muhammad Ibrahim Ali, his projected father, as OPW3, and also Sri Dipul Boro, Dipul Boro, the village headman, who had exhibited his signature in Gabura's certificate within bracket exhibit 15 as exhibit 15 of the 1, as well as another Gabura certificate within bracket exhibit 16 relating to his projected mother and his signature was exhibited as exhibit. His signature proved as exhibit EXT, exhibit 16 within bracket 2. And he had exhibited serial number 76 of the register as exhibit 15/3 within bracket 3. Accordingly, it is submitted that the petitioner has been able to establish his link with his protected father. Next, in respect of the stand that the original evidence was discarded and the Kambur and the school certificate were discarded. Reliance is placed on the case of State of Assam versus Muslim Mandal, 2013. Then bracket 1, bracket close GLT 809. The said judgment was also relied on for the purpose of not being furnished not being furnished the grounds of suspecting him to be a foreigner. Accordingly, comment is submitted that the evidence of the petitioner was wrongly discarded and therefore interference with the impugned opinion is called for. Next paragraph. Have we left out anything?
That's it.
In our dictation, have we left out anything of your submission?
No.
Next paragraph. Per contra, the learned standing person for the FT matters, FT and border matters has submitted that in respect of the claim of the petitioners that since he was born in India, Section 3 of the Citizenship Act would be applicable, he has submitted that the special provision of Section 6 capital A of the Citizenship Act would override the general law regarding Section 3. And therefore, if the petitioner is unable to demonstrate that he is a bona fide citizen of India, by application of Section 6 capital A of the Citizenship Act, the petitioner can still be declared to be a foreigner. Moreover, it is submitted that not only the petitioner has not been able to establish his link with Ibrahim Ali, Muhammad Ibrahim, his projected father, but even his projected father, Muhammad Ibrahim, has not been able to establish his link with his projected father, Songse. Full stop. in support of the submissions that uh, the school certificate within bracket exhibit Q that clause is inadmissible in evidence, comma, reliance is placed on the decision of this court in the case of Jalaluddin versus JALN, Najmuddin, UTTI versus Union of India and others, 2018, within bracket 4, bracket close GLT 354, within bracket para 24 and 25. In
respect of Gauhati certificate, Lordship.
Congress info. Sweet, Congress info. That the oral evidence of parents would not be sufficient to prove citizenship. Reliance is placed the decision of this court in the case of Noor Begum, NURBEGUM versus Union of India and others, 2020, bracket close 3, bracket close GLT 347, and ASIA, ASIA, Asia Khatun, KHATOON versus Union of India, WPC 4020 of 2017, decided on 21/11/2019. The second case, Asia Khatun, is para 7. Noor Begum, what is the paragraph?
Lordship, paragraph 6.
Noor Begum, paragraph 6.
Okay.
Accordingly, it is submitted that the petitioner has miserably failed to prove his link with his projected parents and to show that he is not a foreigner. In that Muslim young girl, in bracket, write two of the paragraphs, write 121.1, 122.1, and 124.1, 125.1. Anything we have left out?
Lordship, one thing, Lordship, I want to say, Lordship, regarding notice, Lordship, grounds, Lordship, Dukhi Ali's case, I want to rely, Lordship. See,
In support of
WPC
his- in support of his-
3805.
Just a moment, in support of his submissions that what should be the contents of the notice
Yes,
in relation to the grounds of arrest, the grounds of suspecting the relation to a foreigner, the reliance is based on the case of
Dukhi Ali, DUKHIALI, alias Dukhumia.
Mia. Mia is spelled as
Lordship, MIAH.
Mia. Yes, what is the citation?
Lordship, it is reported, but reported number is not with me. WPC 3805 of 2016.
WPC
805
3805
of 2016.
2016, decided on
8/3/2018.
8/3/2018. And what is the citation, what is the paragraph?
Lordship, no, notice regarding that point, Lordship, grounds may be mentioned in the notice itself, need not be elaborated or furnished separately. Paragraph, Lordship, whole judgment is, Lordship, detailed judgment, Lordship, elaborately discuss all things, Lordship. And Lordship, para 29, Lordship, after 28-29.
28-29. Okay. So this is the submission, sir. The order would be that the arguments are concluded, the order is up. This is the question, otherwise I'll forget. We are reserving the judgment. We have just recorded your submissions so that we don't make a mistake.
And para 112 and 113 also relying of Muslim Mandal Lordship. Para 112 and 113.
Mr. G. Sharma, Muslim Mandal, para 112 and 113.
Three. In respect of certiorari.
Hmm?
In respect of certiorari jurisdiction Lordship.
In respect of certiorari jurisdiction.
My Muslim Mandal, one,
This is it.
You recorded, that's why we are dictated in your presence. Mr. Biswas, you are sitting for some long time, but we'll have to rise. We'll have to rise today. I'm so sorry.
That's why I'm enjoying my friend's argument and your queries argument. I have learned many things today also.
Learning from here. No, Mr.
No, definitely.
Mr. Biswas,
Every day we get so many new
we have
things.
so many things to learn from you. But we are sorry.
No,
we will
no
have to
matter.
rise. Just tell the, because now the next date of hearing would be going after Bihu.
Yes, my lord, I've got to, because I will be busy, my lord, in this nowadays. Because Bar Council election has come up, that's it.
Oh, acha. We wish you best of luck,
Thank you very much.
but it goes after Bihu because we can't
Obliged,
accommodate
obliged.
these days.
Super. And okay.